So what I'm going to talk to you about today is complaints procedure. I know that's a big issue, how you can sort of force tenants, if you like, to consider the complaints procedure, what to do if they don't, if they've issued prematurely, and what the potential cost implications are. So I'm going to cover that. I'm going to look at the position on cost claims, particularly small claims arguments, both pre and post allocation, and then just other common cost issues which tend to arise in almost every case. And hopefully there'll be some time for questions at the end. In preparing for this, I thought, let's go back to basics and actually look at the pre-action protocol and what it tells us all that we should be doing before we issue proceedings. The whole purpose of the protocol, of course, is to avoid litigation, and that seems laughable with the amount of cases I see where it seems that the claimants seem to be in a rush to issue proceedings for some reason. The second point is, of course, to make sure that the repairs are being conducted efficiently and quickly. And of course, we have to put the tenant at the centre of this. If their property is in disrepair, the idea is that you fix that as soon as possible. Now, one of the problems I see quite frequently is actually claimant law firms, and I'm not labeling them all with this, but I've just experienced this, is where claimant law firms actually say to the tenants, don't let them in, don't let the landlords in, and landlords are having to issue injunctions to try and get into the properties to undertake the repairs. Now, that seems to fly in the face of the pre-action protocol. The whole point of it is to allow you to get in there and conduct the repairs. Now, of course, we all know that one of the reasons they don't want the repairs conducted too soon is because once the repairs are eliminated, there's a good chance it's going to be pushed into the small claims territory. But it's worth reminding any claimant law firms where it seems that you're being prevented from going in and undertaking the repairs that is part of the pre-action protocol, and there can be cost consequences if they don't comply. Now, for those of you that are tenants, representing the landlords, of course, the other issue is making sure that tenants are properly compensated and quickly. So quite often we see claimants that are issuing because they've sent the letter of claim, they've sent you your expert evidence, and there is no offer forthcoming. It's going to be very difficult to challenge the reasonableness of them issuing proceedings if they've given you all the evidence and you're not making a settlement offer at all or within a reasonable time period. So that's worth bearing in mind. And of course, all of this is designed to keep the cost down. So I know you're all familiar with this, but I just thought from a cost perspective it's worth reflecting on it. I think it's also worth reflecting on the aspect of personal injury, because it's something that again seems to be overlooked, and there's this tension as to whether you're following the PI protocol or the housing protocol. So just in case you haven't seen it, 3.5 is there. Effectively what 3.5 says is that if the element of personal injury is quite insignificant and just requires a GP letter, then you can follow the housing protocol. Whereas if it's a proper PI claim, if I can call it that, then you should be following the PI protocol. And it goes a step further to say that it may well be reasonable to separate them. So you have the housing claim and the PI claim entirely separate, which I think there's some sense in that. And of course, from your perspective, if there is a separate PI claim, that will definitely be captured by fixed costs. Whereas housing, of course, at the moment, if there's any element of disrepair or specific performance, is not caught by fixed costs. So worth bearing that in mind. And again, if you want to separate the two, you can direct them to 3.5 and say, well, let's deal with PI separately and let's deal with your housing separately, so you don't get that merger of costs, if you like. It's a duty upon all parties to consider all forms of ADR, and I'm leading up to the complaints procedure. And this is the critical point, is that the courts take the view that proceedings should be an absolute last resort, and that they shouldn't be issued in particular where settlement is still being explored. Parties should be aware that the court will take this into account, the compliance with the pre-action protocol, when deciding who should make an order as to cost. So it's enshrined within the pre-action protocol that if you don't follow this, it's something that the court will take into account. Whether they do that enough is debatable, but it's something that the pre-action protocol says that they will. Now, of course, ADR is expressly provided for within the pre-action protocol. It tells you the type of ADR that you should be considering, and it separates it between council tenants, housing association tenants, and even private tenants as well. And under all of these, underpinned is ultimately how can we resolve these disputes efficiently. So there's the obvious reference to mediation, but in all of these, there is a suggestion that you should be looking at the council's or the tenants, or the landlord's own complaints procedure. It's enshrined within all of this. So again, it's part of the pre-action protocol that claimants ought to be considering whether there is an efficient complaints procedure that can resolve their dispute. So what about the reality then? What actually happens? Well, we all know that claimants typically don't follow the complaints procedure by the time you've got a letter of claim, and their solicitors probably are encouraging them to send letters of claim and follow the procedure. The reason being, I suspect, is that under a complaints procedure, typically tenants won't recover their legal costs. So if they've gone to a lawyer, they've signed up to a CFA, sometimes they may feel compelled to follow through with that claim. And of course, even though typically costs aren't part of the compensation offer under a complaints procedure. There is no reason why a landlord couldn't say, well, we are going to offer to settle your claim for this, and since you clearly have already instructed a lawyer, we will compensate you for your reasonable costs as well. You probably don't want costs to be the only barrier to not resolving these complaints, because if at that point all they've done is a letter of claim, well, it's going to be far less costly than if they go on to issue proceedings and say, no, we're not accepting it. One of the issues that we often see is actually complaints procedures not being effective. And it's a real shame. We certainly in some local authorities, they are very aggressively, as soon as a claim's been issued, they're saying, if you haven't exhausted our complaints procedure, we're going to have a stay and we're going to explore ADR and our complaints procedure. Now, that's all well and good, but if you follow your two-stage complaints procedure and ultimately that doesn't resolve it, all you've done is escalated costs and proved to the courts why it's an inefficient use of everybody's time to follow these procedures. So my plea to everybody is, if you are going to be forcing these complaints procedures, make them effective, stick to your own timeframes and try and resolve these claims as best you can, because there's nothing better than, as these advocates will do, is if they turn up to a case management decision and there's an allocation argument and they can say, well, statistically, 97% of our complaints are resolved, and we've got data to back that. Whereas if statistically the claimants can show that actually only 10% are effective, then that's perhaps going to influence the court's decision as to whether to impose a stay or not. And there's often a strategy as well, I see by many local authorities now, as soon as they receive a letter of claim, if there hasn't already been a complaint, they will treat that as a complaint. And they will say, okay, we are going to invoke our complaints procedure. We're now going to engage directly with the tenant. They tell the solicitors this, we're going to engage directly with the tenant because we have a landlord and tenant contractual relationship, and they can keep you updated if they wish to do so. And of course, what tends to happen then is the tenant just wants the repairs to be conducted and perhaps some offer of compensation. So what about non-compliance? Well, if a party doesn't engage with ADR, then there may be cost consequences, proceedings may be stayed. And of course, we've seen claims where parties have been deprived of all or part of their costs for not engaging with ADR. We've seen winning defendants who have said, well, we were invited to go to mediation, but we had such a strong defense, we thought, what's the point? They're never going to just discontinue their claim, so what was the point of mediation? The court said that's not acceptable. There is very rarely a claim that is not suitable for mediation, and in that case, deprived them of 50% of their costs for refusing to mediate. Now, they may as well have just gone to mediation and say, well, the only option available is to discontinue your claim. But the mere fact that they refused it meant that there was a cost sanction. So it's something that the courts are really coming down hard on when it comes to non-compliance with considering ADR. And it's a matter that the court not should take into account when considering costs. The rules say that the court will take it into account when considering costs. And that's both when determining what cost order to make and also when assessing costs. So starting with this complaints procedure, then in summary, I think it's really wise for claimants to exhaust the landlord's complaints procedure before they send a letter of claim, because if they do so and it's unsuccessful, then there could be no complaints by the landlord for whatever steps then they take. And of course, there's a little bit of justification, if you like, for the claimants to fast track issuing proceedings. They send a letter of claim, they say, right, you've had enough time, you haven't dealt with our complaints procedure, so we are going to be dealing with this very efficiently now because the tenant has been living in these conditions for so long. But I think it really covers the claimant's back if they exhaust the complaints procedures first. As I've already said, it's really important that landlords have a really robust complaints procedure, because for all the reasons I've already explained, if it's not effective, it will come back to bite you. And as I've said already, if the complaints procedure has been exhausted, then a landlord cannot really have any complaints. But if it's not exhausted, then there is a risk on costs. So hopefully that's a bit helpful in terms of complaints. So what about pre-allocation arguments and post-allocation arguments? Now, quite often I get the sense that allocation cases are being issued purely for the benefit of allocation, to know whether it should be small claims or fast track. And then 9 times out of 10, they settle within a couple of months of allocation when it's gone one way or another. So if it's been allocated to the fast track, everybody knows where they stand, and equal with the small claims track. But it's important to acknowledge 46.13.3 in that the court has the power to assess the costs based on the track that was likely to be allocated. So it doesn't matter that there hasn't been an allocation. If we can put together a justified argument to say this would have been allocated to the small claims track, the fact that it wasn't issued is not relevant. 46.13 gives the court the power to assess the cost based on the track that was likely to be allocated. And of course, you will all be aware of 27.1. If the value of the repairs and the value of damages are both under £1,000, it's likely to be under the small claims track. And you'll also be aware that the reason that's attractive to landlords is because of the limits on costs. Important to note, these aren't fixed costs, these are capped costs. So there's quite often the argument, well, if it's a Part 36 offer, then it's fixed costs and everything else, but these are actually capped costs. So in theory, you still have an assessment, but the assessment is limited to £750 for the expert and up to £260 for the profit costs, essentially, if it's allocated to the small claims track. The rules are actually silent as to whether it's plus VAT. I've always treated it as plus VAT, just because I think, well, if you're already knocking them down to £260, then an extra £52 won't hurt. But these are the reasons why these allocation arguments are so important and so common. And I'm sure you're all aware of Birmingham versus Lee as well. And just in case anyone isn't aware, of course, this was a case that went to the Court of Appeal. The claimant was essentially arguing for fast-track costs up to the date that the repairs were completed. The district judge at first instance said, no, I'm going to allocate the whole thing to the small claims track. It ended up going to the Court of Appeal, and what the Court of Appeal decided, as I'm sure you're all aware, is that they're entitled to their costs on the fast track up to the date of the repairs, because then the value of the repairs and damages were over £1,000. But thereafter, there was no claim for specific performance, so it was appropriate for the small claims track. So effectively, you had a two-stage cost. You had standard costs up to the point the repairs were completed and small claims thereafter. And that really is the incentive to get in and do the work as quickly as you can, because quite often, small claims track, of course, if you take away disrepairs, is up to £10,000, and very rarely is the claim for damages above £10,000. So once you eliminate the specific performance, you've got a very good chance of putting it on the small claims track. As I say, I'm not spending long on Birmingham and Lee because I'm sure you're all aware of it, but if the repairs and damages both under £1,000 were in the small claim track, if either of those are over £1,000, you're likely to be fast track, intermediate track or multi-track. And of course, Birmingham and Lee deals with what happens if you actually complete the repairs along the way. I've had some recent examples where a claim was issued, the works were completed between the claim being issued and allocation. So by the time it got to an allocation, there was no claim for specific performance, and the judge actually allocated it to one of the fixed costs regimes, because then it just became a straightforward monetary claim. So it was allocated to the intermediate track, and there is an argument at the moment as to whether it should be still some fast track costs up to that point, but there's no authority as to whether you can have standard costs and then fixed costs applying at the same time. So that's going to be a really interesting argument. Ultimately, it's already been allocated to the intermediate track because there was no claim for specific performance. So watch this space, in that you still could be in a fixed fee territory through the intermediate track or the fast track if there isn't a claim for specific performance. So what about post-allocation arguments? I'm sure that for those of you that represent landlords, one of your big frustrations is you have this big argument at the allocation whereby the claimant says this claim is worth £1,001 and the repairs are £1,002, but it has to be on the fast track. And then 2 weeks later, once it's been allocated to the fast track, they make an offer of £750 to the repairs, and they accept undertaking the repairs proposed by your expert, which were valued at £600. And you say, well, hang on a minute, how in good faith can you have put to the judge 2 weeks ago that this claim was worth over £1,000, and now you're making a settlement offer substantially less? Now, I think this case gives us some helpful authority to argue that point. It's a Court of Appeal decision which stated that the principles of proportionality must be considered when orders of costs are made, and the court can consider it reasonable to make an assessment within the small claims track where that was plainly the correct track. So it does give you some grounds, despite the fact that the case has been allocated to the fast track, to say on true construction, this was always a small claim. It has limited success because, of course, you're dealing with provisional assessments. And I don't know if any of you know judges very well, but they've got an hour typically to conduct these assessments when they're under £75,000. So these sort of arguments are not ones that land well with the judges because it requires them to apply their mind and think about it. And where they've simply got a case that's already been allocated to a track, typically they will follow that track. But it does give us grounds to challenge it on an oral decision and go back before the judge and say, well, how can this be right that it was allocated to the fast track when it was plainly a small claim? So we've had much more success on oral challenges than we would on the provisional assessment. But it's just helpful to be aware of that, because if you need to quote it to say, actually, despite the fact it's been allocated to the fast track, it doesn't definitely mean you'll be getting all of your costs. Proportionality, this seems to be an issue in almost every case. The paying party will always say, well, the costs are plainly disproportionate. The receiving parties will say, well, actually, we have to look at the importance to the claimant. And both are true. All the factors of proportionality are equal. So we have the test at 44.35. Costs are proportionate if they bear a reasonable relationship to all of these factors. So the sums in issue, the value of any non-monetary relief, which would typically be specific performance, the complexity of the litigation. Well, it seems the claimants always say this is really complex and defendants always say it was straightforward. So I'm not sure that gets us too far. Now, conduct, I do think, is a really important factor because particularly it works in the favour of claimants if you've got a defendant who hasn't responded efficiently to the letter of claim, hasn't responded to offers, hasn't provided the disclosure efficiently, you've waited 9 months, you've had no reasonable settlement offer, you're left with no choice but to issue proceedings, and then someone like myself comes along and says that was premature and unreasonable. Now, courts will take into account conduct, and of course they're very sympathetic towards the fact that these tenants are living in these conditions, and of course there's been lots of press around that. So I do think that conduct, as well as the wider factors, public relevance and everything else with all the press stories, these are relevant factors. But of course, proportionality is the most subjective and discretional test. It's almost impossible to appeal because it's entirely within the judge's discretion. As long as they apply this test and then say at the end of it, it was or was not disproportionate, then they can't really get it wrong. So it's one of those that it's almost always thrown in, but you never quite know how the courts will adopt it. Now, in my experience, they probably don't adopt it as aggressively as they should. And certainly when this decision came out in 2015, don't screenshot this because I'll spoil my story, this is old news now. But when this came out, it was quite attractive to many paying parties because what was said by the High Court in this particular case is, well, the touchstone of reasonableness is not the amount of what was in the best interest of the party to spend, but the lowest possible amount that they could have spent. Now, that was interesting because that's never been part of the proportionality assessment. Proportionality has always been an assessment of the costs having regard to the 44.3 factors, and there's always been a reasonable range for proportionality. But what the High Court said in this case is, well, actually, surely the proportionate figure should be the lowest possible figure. So this was being thrown around for years and was causing a lot of uncertainty. But sadly, for those of you that do paying party work, the High Court more recently, and certainly there's been a change in the Court of Appeal have given you guidance on proportionality, have really put that case to bed. So if anyone's still relying on that, I'm afraid it's no longer good law. Mr. Eggers, QC or KC in this particular case said, I'm not sure why the touchstone should be the lowest amount. There is a range, and the amount can still be reasonable and proportionate if it's not at the lowest range. So proportionality is still one of those subjective tests of what is the range. There is no guidance. It doesn't mean to say that if a claim settles for £5,000, that a proportionate amount of cost can't be £8,000, £10,000 or £15,000. We really don't know. You have to weigh all those factors equally. And this is the lead authority on how the court should be dealing with proportionality. If anyone's familiar with the West case, it also deals with AT premiums and everything else. But proportionality was a big feature of this case, and this is the lead authority. It replaces Lowndes. Now, what the court described is the process for which you have to determine whether costs are proportionate or not. So what they've said is you have to assess the cost line by line, first of all, determining whether the costs are reasonably incurred and reasonable in amount. If that amount is disproportionate, then there is a second stage test. You go back and you look at different categories of work to ask yourselves whether they are reasonable and proportionate, and if possible, you reduce those costs to try and create a proportionate figure. And what the court shouldn't do is adjust any figures which are irreducible. So things like court fees, where you've got no say over the amount, it's decided by the courts. So the court shouldn't have regard to any fixed amounts when determining or having that second stage assessment of proportionality. And once the court has conducted that second stage test, that is the proportionate figure. There's no third stage. So even if it still feels a bit high, they won't do anything further. Now, in my experience, this is not a particularly attractive proposition to judges. I would have certainly preferred proportionality to be dealt with the entirely opposite way. I would much prefer a judge to say at the outset, this is a figure I think is proportionate having regard to this claim. So anything more or less, or anything more than that will be disproportionate. But no, the courts are supposed to assess everything line by line and then stand back. Now, for low value claims, that's perhaps a little bit more feasible because you're dealing with everything on paper. But we deal with detailed assessments. I mean, the longest detailed assessment I've had in the SCCO was 30 days. And that, for me, is why proportionality probably doesn't quite have the teeth that it was intended to. Certainly when Jackson was talking about proportionality, he was advocating for a far more robust approach for judges to be able to say this is a proportionate figure. And indeed, many of the cost judges in the SCCO originally, before the Court of Appeal decision came out, were doing exactly that. They were saying this is an incomprehensible amount of money to spend. a proportionate amount must be no more than X, for example. And there was decisions like B&M where the courts took that approach, but the Court of Appeal said that's wrong. You can't just pluck a figure out of the air and say this is a proportionate figure. There has to be an assessment. Now, of course, in the context of housing claims, as I said already, I think the courts are quite sympathetic to claimants, and they're particularly not welcome into this argument if the defendants haven't conducted the case perfectly. So in those cases where you have responded to letters of claim really efficiently, you've provided the disclosure, you've made prompt offers, your expert's gone along, produced the report in a timely fashion, sensible suggestions as to settlement, and they issue anyway, well, I think the courts then are going to come down hard on claimants. But otherwise, I think the courts place probably as much weight on the wider factors and the importance of the claimant as they do on the value of the claim. And as I said already, I think conduct is a significant factor the court will take into account. So in reality, for the claims that are under £75,000 where we don't actually get the opportunity to make oral submissions to the court, we very rarely see the West test being applied. You may see it in orders where the court says, well, here's your assessment. If you want me to reconsider proportionality, I will do. And we have had occasions where the court will further reduce the cost because they are still disproportionate. But in my experience, probably the courts aren't being as robust as they were supposed to be when applying the test of proportionality. So just to manage your expectations there, because all my clients say this is wildly disproportionate, you have to knock it down from £20,000 to £2,000. And I say that's great thinking, but we have to follow a process, and sadly that process doesn't often lead us to £2,000, but we'll get it to £3,000. So what about hourly rates? Again, this is an issue which arises in almost every case. What about the guideline hourly rates? Do they apply? Don't they apply? Well, I'm just going to share my experience with you. So the guidelines has been quoted to you on many occasions, I'm sure. It's intended for fast-track cases or the end of interlocutory applications. That's what it's intended for. The guidance actually says it's there for judges who don't deal with cost day in, day out, and therefore don't know what the market rate is for hourly rates and everything else. And of course, we all know that they're not binding. So what have the courts done? Well, it seems we've got a different approach by different types of court, and which might seem quite bizarre, but what we've effectively got is we've got the Court of Appeal and the High Court dealing with pretty complex cases, very heavy interlocutory hearings, appeals and things like that. They're saying the guidelines apply, and then we're having cost judges saying the guidelines don't apply. So here's some examples, and this will be, again, if you deal with costs, you'll see these arguments quoted all the time. Now, Lord Justice Mells in Samsung started this whole notion of clear and compelling reason. He said if a rate in excess of the guidelines is to be charged, then there has to be a clear and compelling justification for that. And that really has landed with the High Court. That's something that has been applied left, right and centre. So we can see Simon Rainey, KC, applying Samsung, stressing the exact same points. The Court of Appeal have said there needs to be a clear and compelling reason. So therefore, we are applying that in the absence of a clear and compelling reason. So in all of these cases, which are complex High Court cases, the guidelines are being applied. Same, Paul Matthews down in Bristol, Honour Judge Matthews, he is passionate about applying the guidelines. If you can get more than the guidelines out of Judge Matthews, you're doing really well. He is passionate about applying them. And in a case of Otto, where my firm were involved actually because we did the cost budgeting, again, he said if a rate in excess of the guidelines is to be charged, you have to provide this clear and compelling reason. So we've got the High Courts and Court of Appeal saying clear and compelling reason, but none of these decisions that I've taken you to are decisions of cost judges. Cost judges up and down the country taking a completely different approach. This is a decision from Cost Judge Rowley. He's now the senior cost judge in the SCCO, so a very good authority. And if any of you have the experience of going before cost judges, you will know that they simply do not apply the guidelines as rigorously as any judge in the regions. I think this statement from Cost Judge Rowley is helpful. He says, I accept the guideline hourly rates may be a useful starting point. However, he said, I do not consider that the guidance given by Lord Justice Mells for the need for a clear and compelling justification extends with any great force to this particular situation. So the situation he's talking about is detailed assessments before specialist cost judges. And he said, well, when we come before a cost judge, we're going to look at 44.4. And by reference to the guidelines being a starting point, it's a clear understanding that it's not the end point. So we have the most senior cost judge in the SCCO saying the guidelines are just starting points. And effectively, if you know better, not to apply the guidelines. But of course, you've got judges in the regions who are dealing with interlocutory applications who don't specialise in cost. They don't know better. That was the whole purpose of the guidelines. So what does that mean for the cases you're dealing with day in, day out? Well, paying parties always seek to apply the guideline hourly rates in most cases, well, pretty much in all cases, even in multi-track complex cases, paying parties will try and apply the guidelines because you never know. We all rely on Samsung and say this should be reduced to the guideline hourly rates. But in practice, what do we see? Well, in practice, I see that in most fast-track cases, the guideline hourly rates are applied, and in most multi-track cases, some form of enhancement is applied. So that is my experience. Now, of course, most housing claims, or we deal with some other types of claims for local authorities as well, but most of those do sit within the fast track arena, so therefore the guideline hourly rates are most likely to be applied. And we see some really high hourly rates, but we can see straight away receiving parties will often cave in and say we will take the guideline hourly rates. Now, just on the subject of rates is the grade of fee earner as well, and if you are dealing with your own costs, do just check the grade of fee earner that's stated in the bill of costs is actually the grade of fee earner, or is the appropriate grade for that fee earner, because we do sometimes see claims for people that are grade A fee earners, but actually you do a bit of research and work out that they're not. But what Master Riley was referring to was the 44.4 test when considering hourly rates. Again, it's similar to the proportionality test. You have to look at the conduct of the parties, importance, value, specialist knowledge, etc., etc. So that is the test that the court is supposed to apply when considering hourly rates. And again, just step back. When the court is assessing these costs, as I said earlier, they're under £75,000. They're giving themselves an hour to assess the costs. So you throw in small claims arguments, you throw in premature issue arguments, you throw in hourly rates, and then we've got our line-by-line objections. The court is looking for a fast way through these assessments, and that's why a lot of these points don't often land with judges, because it requires them to think about it too much. They tend to take the route of least resistance. So what other points typically arise? Well, Part 36 is often an argument that's used to say, well, it can't be small claims because Part 36 doesn't apply on the small claims track. So therefore, by making a Part 36 offer, implicitly you're accepting this is fast track. And I'm not quite sure that's right. So I've quoted Part 36 there. And of course, Part 36 specifically provides that except whether recoverable costs are fixed by these rules, costs are to be assessed on a standard basis. Now, as I described earlier, the small claims limit is not a fixed cost. So they are not fixed, and therefore 36.13 doesn't apply. But 36 is entirely silent as to Part 27. There is nothing that says that Part 27 does or does not apply. So in my view, I think Part 36 can apply to small claims. The purpose of Part 36 disapplying is the benefits. So if you make a Part 36 offer, a case is allocated to the small claims track, you go to trial and you beat that Part 36 offer, you can't get the benefits of Part 36 because it doesn't apply. But the mechanism of Part 36, which is there to say, here's an offer I want to make. If I make you this offer, I'm also going to pay your costs in addition, but those costs are going to be reasonable. I don't see why that cannot be an appropriate mechanism to use for a case that might be allocated to the small claims track before it's been allocated to the small claims track. And we've successfully argued that despite the fact it was a Part 36 offer, despite the fact it was pre-allocation, we can still get or limit the cost to the capped costs, not the fixed costs, under the Part 27. So an important point to mention, and Part 36 is used as a pushback to why you can't have costs on the small claims track. So what other issues do we tend to see? Triage reports. Now, I know that for many landlords, this is a real bugbear, these triage reports. And I've heard rumours that these are effectively people knocking on doors and saying, can I have a look around your property? And if you've got a claim, I'll sign you up to a CFA. I don't have any proof of that. I don't know what they are. Now, my issue with triage reports from a paying party's perspective is, in principle, if you've got an in-house surveyor, as many local authorities do, there's nothing wrong with an in-house surveyor in a law firm going in and looking at the repairs and doing a report and saying, here's what repairs I think are needed. But quite often we have these triage reports done at the outset, arguably before the CFA, but that's another argument. But then they go and instruct an expert. Now, in my view, the simple argument to disallowing any work in relation to the triage is, well, that's duplication. You can either have your triage report or you can have the expert report, but you can't have both. So that's my issue with triage reports. Now, of course, if a claimant does a triage report, and it's usually done in-house, and they don't then instruct an expert, they rely on that triage report to say, well, here's our letter of claim. We've done an initial inspection. Here's the works that we think are needed. It's been done by a surveyor. Here are the works that we think, and here's the value of those works. Can we just do a quick deal? Well, that would be quite great for everybody because we're saving a lot of time and money, and that would be reasonable. But then to go off and instruct an expert, to my mind, is plain duplication. I've mentioned the grade of fee earner point. Just be alive to ensuring that the grades that are quoted are correct. I have to say I'm pretty harsh when it comes to grades when I'm dealing with pay and party work. I don't think I've ever allowed more than a grade C fee in there for any of the relatively low value claims unless they stray into the multi-track. And the reason for that is we see these claims being conducted very competently by experienced paralegals, etc. So I don't see why anything more than a grade C would ever be reasonable for the vast majority of these claims. Experts' fees and independent experts in quotes. Now, there's two issues here. One is the value of experts' fees, and you'll all know that the cost of these reports can range massively. Anything from I've seen as little as £300 and I've seen as much as, well, thousands of pounds. It's really difficult for a cost judge. And bearing in mind, a lot of these district judges may not specialise in housing. They may not have even done civil litigation. They may be family lawyers that have become judges. They have no idea what is the going rate for a surveyor. So we actually have a witness statement which annexes a number of invoices from across the country, from London to Birmingham, Bristol. And we said, look, here is the range of what experts are charging for these reports. And the fee that's being claimed in this particular case is well outside of that range. Now, judges like that because you're giving them evidence. You're saying, well, why is it in London for a 3-bedroom house they're charging £800, but yet in Leeds for a 1-bedroom flat someone's charging £1,300? And by the way, that expert company is also owned by the claimant law firm. Now, that's a real issue. That is a real issue in my view. And in my view, I think the issue with that is not the ownership of the expert firm, is the fact that it's not been declared. I have real trouble with the fact that they are proposing single joint experts and they're not notifying you of the fact that, by the way, we've got an interest in this company. Now, we've run this point to court. And what the court said is, okay, that there was something dishonest here. They probably should have told you that it wasn't an independent expert, but it didn't really matter because you didn't go with a joint expert anyway. You got your own expert. You settled on the basis of what your expert opined upon, and therefore I'm going to allow them something because even if it wasn't their own expert, someone had to do the report, slash the report in half. But I do think it's really problematic. I think it's really quite dishonest to say, I would like to propose a list of experts to opine jointly for us both, and not declare the fact that they've got some interest in that. So call them out as much as you can. You probably need to look into a few of these companies because I think that there is an element of dishonesty in recommending independent experts that aren't independent. Use of counsel. The issue that I have is the pre-issue work. It's where there's lots of advice pre-issue. Now, the moment you start issuing proceedings and you're needing pleadings, of course, barristers not only do a great job, but they're far more efficient in terms of the time that they will spend to do pleadings because they do that day in, day out. But it's something we frequently challenge in terms of those pre-issued cases, because quite often, particularly if you've got grade A fee and is supervising the case, you really have to say what merited an advice from counsel pre-issue. An important point that's often overlooked and can save thousands is fast-track trial costs. Now, of course, you have these big arguments at allocation about whether it should be fast-track or small claims, and then it gets allocated to the fast-track. And as I say, most of these claims settle. But for those that do go to court, remember that the old fast-track fixed cost fast-track trial regime still applies. So there was a limit, and it's about £800 for counsel's fee. Now, it doesn't mean to say that's what they can charge. They can charge whatever they like, but that's the amount that's recoverable. And it's often overlooked that there is still a scale for how much you can charge for attending trial on the fast track. So do bear that in mind. And as I said, misconduct is a feature throughout all of these. Premature issue, compliance with pre-action protocols, it applies both ways. If you're a claimant, you want to be trying to deal with your complaints, you want to be doing things efficiently, you want to be giving the defendants a fair chance to respond and deal with the issues. And if you are a defendant or a landlord, you really need to be proactive with managing these claims. And I know that's difficult because everybody is incredibly busy, but it's really difficult for us to push back on the costs if things haven't been responded to, offers haven't been made, and therefore costs are racking up because, as I say, the courts have a lot of sympathy for the claimants in those situations. Detailed assessments, of course, for any of you that have experienced them, are very unpredictable. It can depend on the judge on the day. I've had cases where we've gone to an assessment, I've seen who the judge has been allocated to the case, and I've said, we've got to settle this because I know the approach they will take on costs. But it differs judge by judge, court by court. My experience, if you are a paying party, if you can knock the cost down by 40, 50% without negotiations, then it's probably best to avoid the uncertainty, because we have sent cases off to be assessed and been absolutely baffled with the amounts that have come back. And we think, how have you justified allowing so much in cost? But it's very rarely worth a challenge. It's not worth an oral hearing and certainly not worth an appeal. The pre-allocation arguments, they're slightly unpredictable, but we've had a lot of success in saying, well, it settled for less than £1,000. You settled it on the basis of our expert evidence, which said that the value of the repairs were £800. But as I say, we have a lot of success, both in negotiations and in court, in saying the small claims limit does apply. I was honest with you earlier and said that the reallocation arguments are less attractive. I think that as a matter of law, they are attractive, but in practice, the judges just don't seem to want to deal with it at first instance. And then you've got a decision as to whether it's worth a challenge or an appeal. And of course, the rest depends on the judge on the day.